Nancy Cavey, National ERISA and Individual Disability Attorney, and I want to welcome you to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I have to say this, so now I've said it. But nothing will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games the disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Are you the owner of a small business? This week, we're going to be touching on what every business owner and professional practitioner must know about ERISA disability insurance. If you don't own a business, there's still some things I think you need to learn. I'm going to be talking about three things today. First, is your policy governed by ERISA or is it an individual disability policy? Should a small business owner being paid disability insurance benefits take a draw or a distribution? And lastly, don't mess with a disability carrier and fail to tell them about work activity, a tale of how one attorney destroyed his disability case. Let's take a break for a moment before we get started.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. You ready to get started? The first thing I want to talk about is whether or not your policy is governed by ERISA or is it an individual disability policy? And I'm going to do that by telling you the story of a Florida radiologist who argued that his employer-provided disability insurance policy fell within what's called the safe harbor provisions and was therefore exempt from ERISA. Now, I know this is a lot of law and legal stuff, but I think you need to understand this foundational material. So the legal question of whether a disability policy that you purchase through an insurance agent and personally pay premiums is governed by state or federal law is rarely an issue because, as a rule, an individual disability policy is going to be governed by state law. But that's not the case necessarily when you have a group disability policy that's provided by your employer. Now, is that an ERISA disability policy, or can you make the argument that the policy falls in what's called the safe harbor provisions of the ERISA Act? Now, this sounds like a dry topic, but it's a very important topic because you, the policyholder, would rather file a lawsuit in state court on a breach of contract theory than be stuck with the limited remedies of ERISA and the arbitrary and capricious standard of review. And that will make all the difference in your case. So how does a court decide if an employer-sponsored group disability policy is exempt from ERISA? Now, it goes without saying that ERISA is a pretty complex federal law, and there is something called the safe harbor provisions. And I'm going to tell you about that. And I'm referencing a case called Allen versus First Unum. It's a Florida case. And I think it's a good example of the safe harbor provisions analysis that a court is going to use to determine this issue. So let me set up the facts. Radiologist Dr. Marcus Allen had 5 disability policies through Unum at the time he became disabled. 4 were individual disability long-term insurance policies that he had purchased on his own through an insurance agent, and he personally paid the premium. Now, there's no question that those are IDI policies. However, the 5th policy was a group policy that was administered by Dr. Allen's employer, Prospect Hill Radiology Group. And I will tell you that I have had this issue myself in my disability insurance practice as I've represented physicians. Many physicians will have a combination of both individual disability policies and policies issued by their medical group. Now, when his claim was denied after being paid for 5 years, he filed a lawsuit, which among other things, he argued that the Prospect Hill Radiology Group policy was really an individual disability policy under the safe harbor provisions of ERISA. Because again, he wanted to be in state court. Dr. Allen argued he wasn't an employee, but a shareholder, partner, or owner of Prospect Hill. And as a result, Prospect Hill's plan wasn't governed by ERISA. Now, The Code of Federal Regulations establishes a regulatory safe harbor, which excludes ERISA-covered employee welfare benefit plans that are offered by an insurer to an employee. To qualify for the safe harbor exemption, there are 4 requirements that you have to meet, and you have to meet all 4 of them. First, no contributions are made by an employer or an employee organization. 2, participation in the program is completely voluntary for employees and for members. Thirdly, the sole function of the employer or the employee organization with respect to this program is, and without endorsing it, is to allow the insurer to publicize the program to its employees or members, to collect premiums through payroll deductions or dues, and to remit them to the insurance company. And then lastly, the employer or the employee organization gets no consideration in the form of cash or otherwise in connection with this disability program, other than reasonable compensation, excluding any profit, for the administrative services actually rendered in conjunction with payroll deductions or dues checkoffs. You have to meet all 4 regulatory requirements to qualify for the safe harbor provision. ERISA is not going to preempt state law claims for the payment of disability benefits that don't fall under the safe harbor provisions. So what did the court do? Well, the court disagreed with Dr. Allen's argument that because the partners didn't perform any functions concerning the group policy other than to make the premium payments, that the 3rd element was not met. Prospect Hill had endorsed the group plan. They had purchased it. They served as the plan administrator. And the court said, look, that was sufficient to meet the 3rd test. And as a result, the safe harbor exception was not applicable. And unfortunately for the doctor, the Prospect Hill policy was governed by ERISA, and he had to deal with the arbitrary and capricious standard of review, which is tough to overcome. Okay, got it? Let's take a break.